Hello, hello, hello. Welcome to the Tell-A-Law Wednesday weekly webinar. Thank you for joining us. For those who have been attending every week, thank you for your participation. For the new people, thank you for joining. And a big shout out to all those people on live YouTube. Well, today we've got a number of things to discuss. I'm sure you all are concerned about what's happening with the green cards. We're going to talk a little about the concerns about perm downgrades when you're downgrading your application, and a number of other things, and of course, answering all your questions. So let's give people a few minutes to join, and then we will get started. I hope everyone is doing well, and all your family and everybody's staying healthy. So this is September 22nd, 2021. And we're going to talk about the green card outlook. The October visa bulletin in Chats with Charlie was discussed last week a little bit. So the dates of EB5 retrogressed for about 2 months. Dates for EB2 moved forward about 6 months. As we stated last week, there was some inconsistencies with what Oppenham had predicted earlier. And we noted that EB3 categories for India and China will exceed in fiscal year 22 the allotment of October, so the dates retrogressed. So he said the USCIS had more information regarding the worldwide EB3 cases because of the increase in demand of visa availability, and it must be monitored to adjust accordingly. So EB3 applicants from last October and November was almost enough to use all the EB3 limits. And retrogression of employment final action dates could happen as early as November. And then he hopes it happens once and the numbers will move forward. And we're hoping for some potential legislative action. If not now, then hopefully in fiscal year 2022. In fiscal year 2022, the employment limit will be about 290,000, the highest amount ever, which is kind of good news. But there are already more than enough EB3 applicants to use all those numbers. 150,000 expected spillover has been added to the normal 140,000, and hence the 290,000 limit. The reconciliation bill, the Senate parliamentarian rejected the option to include immigration proposals in the reconciliation bill. This bill would have allowed green card applicants to pay an additional fee to have their green cards issued faster. However, Democrats expressed interest in negotiating less comprehensive language to be included. Will green card backlog addressed, or will they concentrate on the dreamers is the big question. The big news this week is USCIS has announced, the US has announced that the travel restrictions will be lifted. New international air travel system to allow all travelers to enter as long as they are fully vaccinated. That's great. Existing testing and masking will remain for all travelers, regardless of vaccination status. Americans abroad will be allowed to enter if they remain unvaccinated, but they could be contacted after their arrival to monitor any symptoms. CDC is expected to announce a process for contact tracing just to curtail any problems that this, lifting of the travel ban could, any impact that could have on COVID in the United States. A list of the approved vaccinations are shortcoming, and they note that consular posts are still backlogged, and so visa appointments are still going to remain limited. So in our adjustment of status series for upcoming, for those of you who are filing in upcoming October, there's some really important things to note when you're filing a new when you're downgrading by filing a new petition. Last week, we covered the issue on ability to pay. remember, every time you file an I-140, you have to demonstrate that you've got the ability to pay. So that's really critical. This week, we're going to talk a little bit about the perm requirements, because remember, when people talk about denials or issues they've had, or friends that have had issues with downgrades, it's usually because the attorney didn't submit documentation showing that the applicant met the perm requirements. Even though you've done it in the previous I-140, you still have to do it again. And so you should submit all the evidence that aligns with the perm. So remember, professional for EB3 means a qualified alien who either has at least a U.S. bachelor's degree or foreign equivalent, and who is a member of professions. As long as you meet that requirement for the supporting perm, you can have greater than a bachelor's degree, but you can't have less than a bachelor's degree. So the USCIS 2007 memo about preserving the perm says that, that memo stated, and as I've talked about, that the perm remains alive as long as it was filed within 180 days of certification. You can use that. That means that live perm can then be used for subsequent filings. But when you file, and because you don't have the original perm, you have to make sure on the I-140, your attorney does, that it is noted that you're going to request a duplicate perm from the DOL. Now, that doesn't happen automatically. You have to make that request. You not only do that in the form, but we also do that in our cover letter in big bold letters, so that they can use the previously approved perm. So, and you want to make sure that there's no irregularities in the original perm. Like, for example, that the requirements that were set forth and the way the perm was drafted, that this subsequent filing is not going to trigger any denial, because if the perm was not either through fraud, misrepresentation, or there was a mistake that was made. We've seen that last year where people came to us after using other attorneys, and then we found out that, for example, the perm was incorrectly approved, and it would be small inconsistencies like the job title, would be incorrect in one place, or the requirements that they had would not match what the ad outlined, or the recruitment didn't take place in that jurisdictional time frame. And so these poor individuals were out. Their I-140 got denied even after they filed the 485. So these are some of the things that you really want to look for when you are filing a downgrade, just to make sure. Dot your I's, cross your T's, because the consequences could be very severe. So if Shaker Chella is available, we are ready to take some Q&A.
Hello, good afternoon. I have.
Now I can hear you.
Muted.
Yeah, now I can hear you.
All right, how are you all doing?
Doing well, doing well.
Okay, we have one question. As usual, if you please submit your question in the Q&A box, and any response in the chat, that would be great. So Mr. Badrinath was just ahead of me by putting his question in the chat from YouTube.
Well, I think it's from YouTube, so they have to place
Yeah,
it.
so I guess for YouTube users, we will probably, just have to take it from the chat. But let's look at the first one from an anonymous attendee. My I-485 and 485J transferred from NBC to Texas Mesquite, but I-765 and 131. Can EAD AP adjudication happen from NBC? Any approval after transfer from NBC to Texas from your firm?
I'd have to check on that and see our stats. But it's probably, there's a couple of things that they do in that process. If your biometrics has already been done, it could very well be that the I-765 and the I-131 is in process to be adjudicated already before sending it down to Texas. There's just no way of knowing. We have a webinar where you can, what's her name? Is it Emily, or I forgot the USCIS helper name, but that's not the only mechanism in which you can contact them. So there are other mechanisms in which you can assess where your file is. And I'm sure our folks will put the link on the webinar.
Okay, next one is from another anonymous attendee. I submitted DS-260 form through online, 1st of this month from India. The status shows complete. In websites, upload the documents online, but the upload option is not appearing. In the email, it was written that send documents to NVC NH. I have two doubts. Currently, the procedure is to send online upload documents or send hard copy by post.
So your doubt is which option should you do? I would say do both. Upload it and send it by, and if you send it by any type of mail, make sure it's a mail that you can track, so you have proof of delivery in case there's any questions.
I think he sent a follow-up, or probably didn't complete it first. So I think he or she says in the website, the NVC process timeframes, the date mentioned in the website for the case review by NVC is application submitted date by online, or the date on which NVC receives the hard copy of the documents.
Right, so it would be, you put it up online, but just in case you're doing a second benefit, or what you can do is put it up online because that is going to be the faster method to get them to quickly adjudicate your application. So I would do that, and if you don't hear anything, then also send it by post. It just won't hurt.
Okay, this question is from YouTube. Badrinath, what will be the EB3 India date in November under final action date? Will EB2 dates take a lead than EB3?
They're saying that the EB3, yes. I mean, I think that can be expected because they say the EB3 applications just last year itself was enough to use all of the worldwide. So they can expect retrogression for final action dates as early as November. Now, remember, if you've got an EB2 and an EB3, which is what I've been telling everybody to do, have both, then you can always interfile if EB2 starts moving ahead. And those of you who've been following me, I predicted this as early as last October, November. I kept saying that at some point, because so many people are downgrading, EB2 is going to start advancing faster. And so it's always a good idea to have both.
Badrinath is following up. He says, will PD 2014 and beyond again wait a decade if no bill materializes from Congress?
I think you will see a bill materializing. I think right now it's, there is a lot of discussion about that, and it has to be addressed. I mean, Otherwise, we're going to lose critical resources. And that is really going to impact the US economy. So we're doing everything we can to make sure the voice is heard, your voice is heard. I can't tell you how much I sympathize with everyone that's been waiting so long. And I know what impact it has on you. You know, your kids may age out if the final action dates retrogress because, well, the good news is if at some point when your children's file, if the final action dates were current and subsequently they retrogress, the good news is they're locked in. As long as at some point your final action date was current, according to the visa bulletin. So we will have to see.
This person who's from India about the NVC online, he's got two follow-up. He says, but online option is not visible. Why? And then I'm presuming it's the same person. Is it okay to send applicants' documents to NVC in two parts? That is delayed by 2 weeks later for the same petitioner's dependents.
Why would you send it in two parts?
I don't know, maybe documents are not ready. That's the answer.
You know, I always think it's better to send a complete file rather than send them piecemeal. It's not going to do you any good, especially if it's just going to be a 2-week delay. That way they have the entire set of documents with them when they are reviewing your case.
All right. Next question is from Michael Tellis. Do you think EB3 would retrogress so much from January 2014 that it would be further back than whatever EB2 goes forward to in November? Current EB2 FAD September 11th. There's currently a 2-year, 3-month gap between the two.
I think you know, because we've been seeing downgrade applications being filed even through the summer. And I think shortly they should have the fourth quarter stats. And that's when we'll be able to see exactly, you know, how that's going to be impacted. But I think you can see already it's retrogressed by 2 months. I think at a minimum, you're going to see another 2 months and then maybe a little more than that.
All right, next question from AA. What is the EB1 time frame current for DS260 after I-140 approval?
What is the current time frame for the DS after the I-140 is approved? Remember that after the I-140 is approved, if you're consular processing, it takes, in normal processing times, it takes 6 to 8 weeks for it to get to the NVC. It may be a little more now. Then the NVC takes about 4 weeks to, you know, reach out to you and get the file initiated, and the typical time frame thereafter would be 3 months. So that's how it was in the typical situation. Right now, we're just experiencing delays every place. Delays at the NVC because they're backlogged, because they were working on, you know, during the COVID time on limited resources. And the consulates are also backlogged. So you should expect, you know, maybe an 8 to 10 months for the processing now. That's just my prediction from what we've been seeing.
Next question is from Vishu. Hi, Lakshmi Garu. My PD, November 12th, EB2. Do you advise downgrade or wait for EB2?
November 2012?
It just says November 12th. So maybe it is November 2012. Yeah,
Yeah.
that's what his response is.
Well, you can
2012.
do both. It shouldn't be an either or. File a new I-140. Make sure that you paid attention to what I was saying about ability to pay issues. Make sure that you review your perm and that all the documentation is sent in as it should be, and file it under EB3. You can always interfile if EB2 when the EB2 advances. But if it starts, because what's going to happen is they're saying that the numbers may not retrogress anymore after November, but they don't know that. And it all depends on how many adjustment applications are going to be filed in the next 2 months. And so if it retrogresses even more, you may not get the opportunity. And we don't know how that's going to affect EB2 applications, because what's going to happen is people are going to start interfiling. So then the EB2 numbers are going to be taken up. So do it now is my recommendation.
I don't see any questions anywhere. So while people are waiting, I just wanted to talk about the EB5. We are still waiting for the appeal. So right now the threshold investment is still 500 and 1,500,000 for regional center. So, I think we explained about how, investors can invest into regional center as direct investors. There's a change in the articles and the constitution of the regional center. They have made changes so that legally, they can take foreign investors as direct investors.
So as people may not have remembered, the threshold for the EB5 program was increased last year. In a targeted employment area, it was increased from 500,000 to 900,000. There was a court case that invalidated the way in which that rule was implemented. The DHS has subsequently appealed it. They have not filed a stay, which means a stay meaning you can't adjudicate any more 500,000 EB5 applications while this appeal is in process. So that means the USCIS will accept the EB5 applications in a targeted employment area for 500,000. The other issue is that the EB5 regional center program, which has to be reauthorized by Congress, was not reauthorized. Not that they won't do it, they've done it for years. It's what are they going to do with the threshold number, right? So we suspect that that's going to be reauthorized. Now, I think, and this is just my opinion, that the reason the DHS filed the appeal is to try to get Congress to act. That's what I think, because they could have resolved this through, the rulemaking process, but they didn't choose to do this. They decided to file the appeal, which I don't think is going to be very strong. So what does that mean? That means that there are typical regional center entities that have now revised their structure to allow for direct investment. Now remember, unlike EB5 Regional Center, the pilot program that allowed for use of indirect employment, EB5 direct EB5s they have to show that they have direct employment. So we've always said, we had a guest on our show a couple of weeks ago, Mr. Daniel Robinson of the North Carolina EB5 Regional Center, where they have now allowed it all direct employment to their direct EB5 investors, which is a great way for right now to get your bang out of your EB5 buck, because you'll be able to do the direct investment. It is in a targeted employment area for $500,000, and since, it's a hotel, it's a Westin, and I'm just using that as an example. They have plenty of documentation to prove that they can create the jobs that are needed, and then some, with a tremendous cushion.
Yeah, just wanted to update on that to the viewers. So if there's anybody who's interested in, in the EB5, just send us an email, info@shalalaw, and we'll be glad to share, the project status of the Westin Hotel project, that the ARC-5, that is the name of the regional center in Greensboro, North Carolina, but the project is, in Durham, North Carolina. The project is in Greensboro, North Carolina, the Westin Hotel. So I'd love to send you guys some information if you're interested in taking advantage of this reduced, $500,000 before a decision is made and for the appeal made by the USCIS.
And
we hope it stays at 500.
Yeah, no, I was going to say I am agnostic when it comes to EB5. What regional center you align with. The reason why we speak about ARC-5 is because the people who are managing it, he is directly talking to you. There's no agents. And we've had, not only with this project, but even with previous projects that they've worked on, there's never been an issue. And so it makes me feel good for my clients, because I know $500,000 is a lot of money. And I just want to make sure that your immigration process is successful with a, known entity, a quality known entity. So, and like Shaker said, the time frame is ticking. Either Congress may up the threshold, or, USC, DHS may, be successful on their appeal. In any given situation, the time is ticking, and this is a great time, as we're talking about green card backlogs, to find a way to, facilitate the process.
All right, that's it. So any interest, just let us know. Send me an email, info@shalalaw.com. Thank you.
And if you haven't, please join us on social media. I'm sure Kara will send the social media links. We've got a Telegram group, we've got Facebook. Share, our information with your friends and people who are, next couple of months are going to be very critical. So let's get the word out. Let's help as many people as we possibly can. And, please, if you haven't, subscribe to our YouTube channel, like, share. We really appreciate that. And I look forward to talking to you next week. Thank you again. And thank you, Kara, for organizing this, and the rest of my team.
Yeah, we have some questions while we were talking on EB5. So should I take them?
Sure.
Okay. Michael Tellis is back. He says, I thought FB spillover goes to the most retrogress nation, that India. So why is Charlie saying that higher ROW demand may also cause India retrogression? Wouldn't Indians benefit from fiscal 2021 FB spillover to fiscal 2022 for EB, regardless of what happens for ROW?
Right, but they say that the number is the highest amount ever. So even counting the spillover, because of the large applications, remember, it's India's retrogress because there's more people filing under that category. And I shared those stats, the fiscal year 2020, what those stats were, and I'll post them again on our Telegram group, but it's substantial.
Anonymous attendee, any insight on the Padilla Paul America's Children Act? Is there any support for this? What can we expect with regard to timeline?
With what?
Padilla Paul America's Children Act.
Yeah, I I think, when it comes to immigration, all the bills that are being proposed are supported both by Democrats and Republicans. But I don't know why the parliamentarian stopped it. Right now, we'll have to see how the pressure mounts as the time is coming close. There are elections next year, and a lot of this, even though the immigrant community per se that is going to benefit this will not be U.S. citizens by next year, there are a lot of supporters of those bills that are, voters. And so I think that's going to weigh in the decision.
Next question from A. Ramdas. As on date after submission of documents for NVC consular processing, how many months to take to get immigrant visa to travel to USA, particularly EB-1A?
I think your biggest, no matter what category, the biggest issue is going to be getting a consular appointment. There are tremendous delays. So in times we've seen from the time it gets approved till you get an appointment, it's about anywhere from 4 to 6 months at best. I think you're going to see at least a 2 to 3 month delay, additional delay on that.
Next question is from YouTube. We are Bethany. Hi, Lakshmi Challa. Thank you for support. Mine is EB2 November priority. What is your suggestion? Are you anticipating any filing dates moving in coming months? EB2 2012 November.
Right. So what I've said all along is you can downgrade right now, right? The numbers, the January 8th, 2014, numbers are good until October 1st. So, I'm sorry, until the end of October. So what you can do is you can go ahead and file an EB3 downgrade adjustments of status concurrent application. And then later, if EB2 advances, and it may not happen until mid next year, we'll have to see, depends on how many people interfile, but you can interfile your EB2 at a later date. You can get the benefit of both, guys. Why would you just want one when you can get the benefit of both?
All right. Then another question from Badrinath from YouTube. What do you suggest? Coming legally into the United States or jumping off the fence from Mexico, get a green card early? Fun intended.
What was the question again? I was so focused on jumping off of the fence. Go ahead.
What do you suggest? Coming legally into US or jumping off the fence from Mexico and get a green card early?
Right. I know that a lot of people are upset that everyone's focused on the dreamers and you feel like you've been disenfranchised and your voice has not been heard. I assure you that I make sure at every opportunity that everyone's voice is heard. I mean, we should care about the dreamers, but we should also focus on employment-based immigration and care about all those people that are in the queue for so long. It is what I call the family separation that no one talks about.
All right. I just wanted to inform the viewers on EB5, the Daniel Robinson's webinar we did. There's a link in the chat. So if you want to, go and hear that, just pick it up. Next question is from Harish Barsiwal, sorry. My question is, I have EAD AP card, but my EB2, EB3 downgrade I-140 is still pending. 3 attempts of PP return. Can my spouse take full-time job on GCAD? Is there any risk for me too, taking a full-time?
Well, remember, the difference between you and your wife, if you're the primary applicant, the only way you can change employers and leverage AC-21 is the I-140's got to be approved. 45's got to be pending 180 days, and it's got to be same and similar employment. So for you as the primary, you have to wait for your I-140 to be approved. So keep trying with the premium processing efforts. Now, as far as your wife is concerned, because she's not the primary applicant, she can take a full-time job, and there's no risk to that.
All right. Next question from Mariangela Basi. Good afternoon. Is it only in November? It is only in November, when travel ban with European countries will be over, that a firm can give a foreign person a sponsorship for job and not before.
No, there are exceptions to the travel ban, and we did a webinar on that. The national interest exception, and for the national interest exception, it's got to be in the national interest of the United States. There are many, different types of categories and fields that are in the national interest. The mistake often people make is they talk about that it's in the interest of the company. No, it's got to be interest of the United States and how it relates to the sectors that are known to be or that they have outlined are critical in order to be successful in the national interest exception.
Next question from an AA. When USCIS not able to utilize all visa numbers due to shortage resources, then what is the use of new bills?
Right. Well, as part of the bill, they had allocated a substantial amount of money. I can't remember off the top of my, but I think it was, lots and lots of money, so that the USCIS could hire new resources and streamline process faster than they have been. Remember, the USCIS has been stripped of resources for the past few years, and in part because of a lot of the Trump administration's policies.
102 billion for 10 years? Is that like the budget?
Yep.
Harish Bariswal is put that number there. Thank you.
Yeah, I believe so. Kara can confirm, but I believe that is.
There's a question from YouTube, Rajesh. My employer is not ready to downgrade my PD June 30th, 2014 EB2. Is it right time to change the organization?
I don't understand, if your employer needs somebody to talk to because he's, he may be worried because of ability to pay issue, but that's because they don't understand that there's many mechanisms in which, you can show ability to pay. Number two, because the numbers are going to be retrogressing and it takes a long time for the I-140 to get approved, people are still waiting from last October. This is a great way for retention. I mean, if you're a good employee, they should want to do this for you. And if they'd like to talk to us, I'm happy to speak with them and discuss, options and strategies.
I think that's about all we have for today.
Okay, very good. Thank you, folks. Thank you, Shaker. Thank you, Kara. Thank you, all of you again for joining, and look forward to seeing you again next Wednesday, same time. Thank you. Bye-bye.